So if you get a letter from lawyers saying that you infringe their client's IP and they're going to sue you if you don't pay them a lot of money and promise not to do it anymore, it can be quite frightening. I think the first thing to do is to take a step back and take advice and try and have an open mind, so that you can listen to advice, understand the risks, and ultimately make your own decision as to what to do based on how you understand the risks and what you want to achieve for your business. So the claimants or the proposed claimants' lawyers are going to expect us to write back to them. And what we write back will obviously depend on our discussions and the approach we've decided to take. If we've got good arguments that would potentially provide you with a good defence to the claim, it's normally worth putting those down on paper quite early on, explaining why we think we're going to win and they haven't got a case, especially if we've found prior art, for example. We probably want to bring it to their attention. There's a question of whether we try to open a negotiation. If you're faced with an allegation of IP infringement, say that your widget infringes somebody's patent, there's a number of things you can do. You can defend it. You can say, well, I don't infringe, the patent's invalid. We may think we've got good prior art, we may think we've got good arguments for non-infringement, but they're probably not going to be 100% certain. So we could decide that we want to manage the risk in some way. So we could say, well, we'd like to keep selling this, but would you agree to take a royalty? Bearing in mind that your patent's probably invalid. If we pay you a bit of money, then you're getting some money from it. We can make a profit, you can make a profit, you can keep your patent, everyone's happy. That's one option that might be considered. We might think about changing the product. Could we tweak the product to take it away from infringement, to make it less likely that it falls within the scope of the claim? Sometimes we can change the product to make it almost certainly fall outside the scope of the patent, for example. Sometimes it's a little bit more finely balanced. But you might have a whole bundle of things which lead to the possibility of compromise. So you may have an idea to change the product which significantly improves your case, shall we say. Your new version of the product is unlikely to infringe, even if your existing product does. At the same time, you might have found some good prior art which actually calls into question whether the patent's valid at all. So, if we put that combination of things to the other side, all of a sudden we're in a position where they don't really want to sue us anymore, because if they do, we're going to counterclaim for revocation of their patent and they might lose it. We still don't really want to get sued, but everyone's then on the same page of, well, we'd like to avoid litigation. Maybe if we have this product that's slightly different, so it doesn't look so similar to theirs, they would be happier. So we can look for negotiated ways out of this. These negotiations can end up being quite protracted, depending on the complexity of the case. Well, some of them happen quite quickly. But I think the real general advice is try and have an open mind. Think about what you can do so that you can try and negotiate in the best interest of your business.